Great. Hello, everyone. My name is Kevin Harrington, and I am the co-chair of the Trust and Estate section. Welcome to our program today, Administering a Probate, What to Do After Your Petition is Approved. Before we begin, we have a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in the BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. We have a few events that are upcoming for the Trust and Estate section. On July 14th, we have a program on omitted spouses. And on July 19th, we have a program on creditor claims. The Trust and Estate section is also accepting applications for positions on the executive committee. Anyone who is interested is well encouraged to apply and join. It has definitely been a very rewarding experience. So please feel free to apply or reach out to any of the committee members if you have any questions. Before we begin, we have a few words from our sponsors. First, we have the Sanborn team. The Sanborn team has been sponsoring the Beverly Hills Bar Association Trust and Estate section since 2006, servicing clients for over 35 years. The Sanborn team gives members and colleagues attractive results and peace of mind with a depth of knowledge of probate, trust, and conservatorship unparalleled in the industry. We also have a few words from Orit Gadish of Geffen Real Estate.
Thank you, Kevin. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate. Interest rates are on their way up and prices are on their way down. If you have real estate that needs to be sold, you may be wondering which sales strategy to employ. Read my latest blog post on this topic. The link is in the chat box. We specialize in representing trustees, administrators, and executors in the sale of commercial and residential real estate. If you'd like to sell a property in as-is condition, we can help you get the property ready for market with a cleanup if needed. If you'd like to consider adding value prior to selling the property, we can support you with that as well. Whether it's a partial or complete renovation, we first conduct our due diligence to determine the most appropriate value-add solution, and then we execute, no cost to the seller until escrow has closed. We also offer staging services and have a designer on our team to ensure properties we're selling are appealing to buyers and are drawing on their emotions to allow them to offer top prices. We're not a cookie cutter renovator. Feel free to reach out to me via text or cell. My number is in the chat box. Enjoy your program, and back to you, Kevin.
Thank you, Orit. In addition to the Sanborn team and Geffen Real Estate, the Trust and Estate section is also sponsored by Glen Oaks Escrow. Maureen Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of Estates Act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that our clients are beyond happy with their experience at Glen Oaks Escrow. We also have our California Title Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. We're also sponsored by Manufacturers Bank. Simplify your banking. Let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estates banking team with the experience to handle all your banking needs. Contact Brian Flores, Senior Vice President and Senior Relationship Manager for more information. I'm now gladly and proudly introduce our very own Beth Acevedo, who will be preparing our presentation and presenting today. I'll now turn it over to Beth.
Hi, everyone. I'm Beth Acevedo, and I'm a partner at the law firm Weinstock Mannion, where I work with individuals on their estate planning needs and also represent individuals and beneficiaries in both probate and trust administrations. So today we're going to dive into the topic of, you're at the point you filed a petition for probate, you've gotten your petition granted, you've got letters in hand for your personal representative, and you have a bond in place if needed, and now what's next? So that's what we're really going to dive into at this point. So the first thing we're gonna cover in greater detail today are a number of topics, including identifying matters that require immediate attention, identifying, collecting, and managing the estate assets, preparing and filing the inventory and appraisal, providing notice to creditors and resolving the decedent's debts, selling estate property if that's something that needs to be done, making preliminary distributions, and then finally closing out the estate. That's sort of the umbrella of everything that's going to happen now that you've got your probate open. So the first thing we want to talk about are things that kind of require immediate attention. These are things that either you directly as the attorney for the fiduciary, or you as the fiduciary, if you're acting in that capacity, need to do to immediately address issues that can come up even before or as you're in the process of opening a bank account and starting to administer the estate. So the first thing you want to do is identify and collect the decedent's assets. One of the things in this process that you'll need to get is a tax identification number for the estate. That number will be needed in order to open a bank account in the name of the estate. Opening a bank account and perhaps a brokerage account, depending on the assets, will be needed in order to transfer assets that are in the decedent's name over into the name of the estate. You'll also want to, in connection with thinking about identifying assets, calendar the date that the inventory and appraisal is due. That is 4 months from the date that letters are issued. We'll get into a little more detail in a bit about what goes into that inventory, but you want to kind of get onto your calendar right at the outset, that 4-month deadline. You also want to start to look for the decedent's debts. So if there are any credit cards that are out there with payments that are due, you want to identify those and, if possible, pay them if they seem appropriate in the near term. You should notify the major creditor agencies, so Equifax, Experian, and TransUnion, that the decedent has passed away. This is an important step just to prevent fraud from being committed on the decedent's Social Security number, and can be done with a simple letter to these agencies. And then you also, and we'll talk about this in greater detail, want to try to quickly identify the decedent's creditors so that you can get notice out to them to get the clock running on their period to file a creditor's claim. If the decedent has real property, there's a number of different things that you should be thinking about. So as an initial matter, you want to identify all the decedent's property. But beyond that, you want to take a look at title to see how title was actually held. Was it just in the decedent's individual name? Were there joint owners? Is the description of the property accurate? You're looking for potential issues that come up with title, and you want to start to think about clearing them up on the near end if possible. You want to check insurance coverage. You want to look to see if there are any mortgages outstanding on the property, and if possible, start paying those in the near term so that you don't fall behind on the mortgage, the estate doesn't fall behind, and then end up in a position where the property could end up in foreclosure. If the estate doesn't have liquid assets, you should reach out to the mortgage lender and negotiate a repayment plan. The key is really communication. As an example, I had an estate once where there was a reverse mortgage on the property, and the lender was very anxious to know whether the beneficiaries intended to repay the debt or whether the plan was to sell. And they started to get letters pretty quickly by collecting mom's mail. They started to see these notices, and we reached out to the lender even frankly before the probate was open and said, look, right now nobody has the authority to take any action. Here's the timeline for when our petition for probate will be heard. Here's the timeline for when we expect to receive letters. Once we receive letters, this is how quickly we can get back to you on what the plan will be as to sale or paying off the obligation. And each step along the way, we updated the lender so that there was transparency on what was happening on the estate side, so that the lender felt comfortable that they weren't sort of just being shirked off, and they were then able to grant some extensions in time to provide formal notice on how the estate planned to proceed. So what I find is communication, particularly with something like a lender, is important with real estate early on. And I find it helpful not just to speak with somebody over the phone, but then also to follow up everything in writing so that you've got clear records of the communications that you're having. In the same vein, if there's a default, if you have a mortgage that already is in default, you want to take the steps to prevent foreclosure if you can, or sort of figure out where you are in the process. Let's see. I noticed that there are some Q&As popping up. I'm just going to wait until the end of the program just so that you all know to answer any questions. So in addition to lenders, you want to look to see if there are any tenants. So if you have rental property, you should notify the tenants that the estate is now the landlord and provide information as to where they should be sending rent payments going forward. If the property is vacant, you should consider posting a no trespass sign and making sure that the property is adequately secured so that you don't end up in a situation where you have squatters or vandalism to the property. In LA County, you can actually file with your local police department a trespass arrest authorization form, which allows the LAPD to actually go in and arrest anybody who trespasses on the property and to enter the property for purposes of doing that. So something to consider doing if you have concerns about potential trespassers. And you also need to provide, as it relates to the assessor for property tax purposes, a change in ownership, death of real property owner statement. This is to advise the assessor's office that the decedent has passed away, so that there will be a reassessment if that's appropriate. You'd file a parent-child or grandparent-grandchild. Well, the latter, grandparent-grandchild exemption would only apply if the death had occurred prior to February 16th, 2021. But there's still a parent-child exemption that could be filed in limited circumstances. So you want to check to see if that would be appropriate. And then finally, you want to look to see if there's any out-of-state real estate. So ideally, you would have thought of this in connection with, establishing your probate to begin with. But now that your client, the personal representative, has letters, they can then open ancillary probate. So that's a secondary probate in different states if the decedent held property in different states that also need to be marshaled. In terms of personal property, you want to get in and sort of take control, or have the personal representative take control of any personal property. To the extent that there's any valuable personal property, you want to make sure it's adequately secured. That could mean moving it to a storage facility. If there's jewelry or other, smaller fine items, moving it to a safe deposit box. The key is that you want to take the measures to make sure that you're protecting any valuable personal property, and that you similarly have insurance in place just in case anything happens to the personal property during the course of the administration. So these are the things you're sort of reviewing at the front end. And then the next thing to think about is tax returns, particularly important if you have a decedent who passes away close in time to the income tax filing deadline, or you get letters close in time to that deadline. So even if you're not able to formally file an income tax return, for example, you want to make sure that you, as quickly as you can, identify all of the income sources so that you can at least, if necessary, make an income tax payment timely on behalf of the decedent, and then work with the decedent's accountant or CPA to get those returns prepared and filed. In that same vein, you need to give notice to various government agencies that the decedent has passed away, and can do that through specific forms. So with the IRS, there's a Form 56 that identifies the personal representative is a fiduciary who's acting on behalf of the decedent. There's a similar form that can be filed with the Franchise Tax Board in California. And then you have to give notice to healthcare services and the California Victim Compensation Board in certain circumstances, which we'll talk about a little bit later. And then finally, kind of in connection with identifying these assets and figuring out the liabilities and opening that estate bank account, you want to help the personal representative implement a structure for managing the estate property. And what this is going to look like will depend in part on the assets that are comprising the estate. So what do I mean by that? If you have primarily liquid assets, bank accounts, brokerage accounts, then the key thing is to move the assets into an estate account that's interest bearing. For brokerage accounts, you would want to, depending on how long the estate might be administered, generally you're going to ask the broker to stop reinvesting dividends because you have an eye toward eventually distributing out these assets, and you may not want to be tied up in new investments. For real estate, we've talked about the idea of updating tenants. If you have a property manager in place, you want to make sure that they're aware that the estate is now the owner. If the decedent owned a business, you need to think about how that business is going to continue to be managed, whether you need to hire people to come in and operate the business on a going forward basis. So this is taking a step back and helping the personal representative determine what steps need to be taken to step into the decedent's shoes and maintain their assets. A key point here, and something that's important to drive home with personal representatives at the outset, is record keeping. So typically as part of the close of the estate, we're not there yet, but you will have to prepare an accounting. By you, the personal representative will have to prepare an accounting of their actions to show, the receipts and the disbursements that were made by the estate during the course of the administration. And the best way to make that a simple process is to keep very good records along the way of all the ins and outs. Ideally, pay for any expenses with checks so that there's a clear trail. And just be prepared then at the end to provide that to an accountant or bookkeeper to help prepare the formal accounting. So those are some of the things you want to think at the near term, like hot button issues that may have immediate consequences. Taking a step back, and some of this is sort of covered in things that you want to think about in the near term, you're going to help, and the personal representative is going to start identifying, collecting, and managing the assets. So we've hit on some of this. So I've listed for you a number of different types of assets that you might think about in reviewing the decedent's records, and the personal representative should think about. Financial accounts are sort of the obvious, but they may have assets like deeds of trusts or other loan receivables. If there were any assets held in a safe deposit box, if the decedent had any privately held business interests. The part of the way that you will be able to identify these assets is by reviewing the decedent's mail, and prior income tax returns. So, early on, shortly after being named, the personal representative should file mail forwarding with the U.S. Postal Service so that they will start to receive all the decedent's mail. And in doing that, should then be reviewing the mail to find information about any assets that the decedent had and liabilities that were outstanding. And also to the personal representative should reach out to the decedent's accountant or CPA, or review the decedent's records for prior year's tax returns that were filed, because those can provide a lot of information on sources of income, which can lead to discovery of accounts, business interests, rental properties that you may not otherwise be readily aware of. You should also look to the state comptroller's website to see if there's any unclaimed property in the name of the decedent. You'd be surprised how often that happens. In connection with identifying the property, we talked about the concept of then bringing it into the estate. So that's actually retitling financial accounts into the personal representative's name as representative for the estate, updating insurance policies, and so that the estate is actually the insured going forward. And then working with an investment advisor, depending on the size, to figure out how to safely invest the assets of the estate during the course of the administration, making sure that any cash is held in accounts that are FDIC insured, to provide, again, as much protection for the estate as possible. If the decedent had any insurance policies on their life, the personal representative should be reaching out to the insurance companies to confirm who the beneficiary was on those accounts, and if it was the estate, or if there was no named beneficiary and by default the beneficiary is the estate, pulling those proceeds into the estate account, and in connection with that, requesting a Form 712 from the insurance company. A Form 712 identifies the owner of the insurance policy, the beneficiary of the insurance policy, and the amount that's payable at the time of the decedent's death to the beneficiary. The Form 712 is particularly important if you are going to need to file an estate tax return, because it's something that you will end up needing to include with the estate tax return when filed. If the decedent had any, personal property that's depreciating, furniture, furnishings that don't have significant value, the personal representative can take steps to dispose of that property in the near term. They don't have to hold on to it during the course of the administration. So that might mean asking family members if, or the beneficiaries of the estate truly, if they have any interest in the property. If they don't, looking for opportunities to donate any items that can be donated. These are for items that have small or no value, where the cost of continuing to maintain and store the property would actually outweigh the benefit of keeping it. So those are steps they can take. A benchmark to kind of think of is that anything with a value below 5,000, small items are things that you can dispose of without having to start thinking about court involvement. And then we kind of hit on before, you want to prepare and file final income tax returns for the decedent. So this is something that, for the decedent, you'll have an income tax return for the proportionate income for a year through the decedent's date of death. Depending on how long the estate is administered and how much income comes into the probate estate during the course of the administration, it may be necessary to file a fiduciary income tax return as well. If the decedent's estate is large enough to be a taxable estate for estate tax purposes, the personal representative is responsible for preparing and filing the estate tax return. The same is true for any gift tax returns that may be required. So if the decedent made gifts in the year prior to their date of death and had not filed a gift tax return prior to passing away, then the personal representative would need to arrange for that gift tax return to be filed by the time that the estate tax return is filed. So 9 months after the decedent passes away, or 15 months if put on extension, to report those gifts. And then similarly, if the decedent failed to file returns, the personal representative is responsible for pulling together the information needed to prepare any late returns and get those on file. This can be particularly difficult. I have actually a couple of states where we have a decedent who was late in filing income tax returns, and finding the records can be the most difficult thing. So you can request transcripts from the IRS to obtain information about the decedent's income in a particular year, but those transcripts don't provide information about any offsetting deductions that might be available to the decedent. And so if there aren't good records, if the decedent didn't maintain good records, you can end up in a position where you are you have an estate that owes substantial income tax if you can't find offsetting deductions. But regardless, the personal representative has an obligation in connection with sort of winding up the decedent's tax matters to file any late returns. And must do that before the estate can be closed ultimately. So, so those are some of the initial matters going through and administering the estate. The next major thing that you need to do in connection with the probate estate itself is prepare an inventory and appraisal. The purpose of the inventory and appraisal is to determine the value of the decedent's estate as of their date of death. And the appraised value is ultimately what will also determine the fee that both the personal representative and the attorney for the personal representative is entitled to toward the close of the administration. So I've included with your materials, the inventory and appraisal must be submitted on a judicial counsel form DE 160 and 161. So DE 160 includes the total value. It's where the personal representative and the probate referee will sign if needed. If there's a bond in place, it's the form on which the personal representative will make representations about whether bond is sufficient after receiving the appraised value of assets. And then DE 161 is an attachment to the inventory and appraisal that's used to report both cash and cash equivalents, and then also any other property owned by the estate. So if you look at form DE 161, you'll see that there's a spot at the top where it says attachment, and then you can insert 1 or the number 2. So on attachment 1, you would report cash and cash equivalents. Those are things like cash deposits, money market accounts, the cash in a brokerage account, proceeds from a life insurance or an annuity that's payable to the decedent's estate. Anything that's reported on attachment 1, the personal representative can provide the information on the date of death value or amount and file it without the need for reaching out to a probate referee. Anything that would show up on attachment 2, which is everything else and includes brokerage accounts, interest in real estate, interest in business, personal property, promissory notes, if the decedent had any receivables, anything that doesn't have a concrete value, you would list on attachment 2 without the value next to it, and then provide the attachment 2 to the probate referee who's been appointed to work on the estate. And the probate referee will then be responsible for actually determining the value. Generally speaking, probate referees are randomly assigned in connection with with opening the estate, although in certain circumstances you're able to actually request one. And although the probate referee is responsible for determining the value of anything reported on attachment 2, you and the personal representative, if you're the attorney, if you're the personal representative, can provide information and should provide information to assist the probate referee in the process. So if, for example, the decedent had an interest in the business, you would provide the underlying formation documents, any operating agreements. Generally, the probate referee will need information on the income and receipts within the business during the period covering the decedent's date of death, and will often also ask for 1 to 3 prior years tax returns for the business. If you've obtained an appraisal separate from what the probate referee will do, so as an example, if you're filing an estate tax return, we'll often have a third-party appraisal company appraise a business interest, in part because if a decedent, for example, owned a minority interest, there might be discounts for lack of marketability and lack of control that would be beneficial to have and report on an estate tax return. So if you have obtained an appraisal from a third-party appraiser, you can include a copy of the appraisal report with your attachment 2 and ask the probate referee, if they think it's appropriate, to appraise your asset at the same value that the third-party appraiser did. The reason that it's helpful to make that request and to provide the supporting information to the probate referee is that if you do have to file an estate tax return, ideally you don't want to have 2 different values for the same property. Because if you do, then you have to report both of those values or perhaps an average of those values to the IRS. So whenever it's possible to have the probate referee end up with the same result, it certainly makes things easier for the estate tax return. And then you just have to be available generally. The probate referee may have questions. They may need to make site visits in order to value the property. And so you and the personal representative will help coordinate to get that done. So the inventory and appraisal is required to be filed within 4 months after letters are issued. That doesn't mean that you have to have every single asset valued within the first 4 months of the administration. What it does mean is that if you cannot value everything within the first 4 months, you should file at least a partial inventory and appraisal for the assets that you are able to value within that period. And then you can submit along the way, 1 or more partial inventories. But before you can close the administration, you have to submit what you have checked at the box as a final inventory and appraisal, so that the court knows that at that point you have identified all of the assets of the estate and valued them as of the decedent's date of death. You don't serve the inventory and appraisal on anyone when you file it. You simply file it with the court. Any beneficiaries or heirs can obtain copies by pulling them from the court's records. And objections to the inventory may be filed anytime before the petition for final distribution is filed and approved by the court. So why do I mention that? If you think that there might be some challenge by somebody that's a beneficiary of the estate over value, you might consider whether it makes sense to provide them a copy of the inventory and appraisal and discuss it with them prior to filing it. I can tell you that one instance where I've seen objections raised is where an inventory and appraisal reported everything belonging to the decedent as community property, when another party in the matter thought that the property should all be separate property. A significant implication, depending on how it's characterized, because community property, you only end up including 50% of the value in the probate estate, whereas anything that was separate property would have included 100% of the value. And in that estate, which was an intestacy, California law would have resulted in a different distribution depending on the character of the property. To that end, on the inventory and appraisal, you report not just the value, but also you indicate the character of the property that's being valued. So generally, you can, like I say, you have to have a final inventory and appraisal before you can file a petition for to close the estate. Even if you only need to file one inventory and appraisal to value all of the decedent's assets, you may end up having to file a second one if you are selling property within the estate. And we'll get to that a bit more, but basically you have to have what's considered a current appraisal of any property that's being sold if the estate is not being administered under the Independent Administration of Estates Act. Similarly, you could have, even if you filed a final inventory and appraisal, you might have to file a supplemental inventory if you find additional assets during the course of the administration. And if you discover that there's an error on the inventory and appraisal, then of course you would file a corrected inventory to fix that error. In that vein, I would say, even after you get the inventory back from the probate referee, carefully review it to make sure that everything looks accurate before filing it with the court, so that if there are any errors on it, you can ideally have those corrected before filing it. So, okay, let's move to our next topic, which is handling debts of the decedent, including creditors' claims. So we've talked on this a little bit earlier, where I mentioned that it's really important to identify the decedent's creditors as quickly as possible after the probate has opened, or even ideally while you're waiting for your probate to formally be opened. The reason for this is that the personal representative has a duty to notify all creditors, all known creditors, known being important there, of the decedent's death. And known doesn't mean that the personal representative has to scour the earth to find potential creditors. Rather, it means that, you know, they have to make a reasonable effort to identify potential creditors through a review of the decedent's records, their mail, and then to give notice to anybody who comes forward as a creditor that the estate has been opened. The notice comes initially through the proof of publication that's filed in connection with opening the probate. And I'll tell you that if you are the attorney for the estate, it's not uncommon to receive calls from creditor agencies even before a probate's formally opened, because they will be scouring those publications and then will want to make sure that they are on the list of creditors who should be paid before the estate is closed. If that happens, you know, before your probate is opened, you should just keep a list of any creditors that have reached out to you. And then once the estate is open, include them among the creditors that would receive this notice. So before we get into sort of the more detail on the known creditors, let's step back and talk about the state agencies that are entitled to notice. So I had mentioned before that you may need to give notice to the Department of Healthcare Services. There's only limited circumstances where that needs to happen. So you need to do that if the decedent received Medi-Cal or was the surviving spouse of a person that received Medi-Cal. So in either of those scenarios, you're required to give notice 90 days after the decedent's date of death. There's no specific form that you have to send, but you should include a copy of the decedent's death certificate, and you should send the notice by certified mail, registered mail, or express mail. And the importance of sending this notice is that it limits the time when a claim can be filed for the Department of Healthcare Services from 3 years to 4 months. So clearly a benefit both in helping to identify the universe of your creditors, but also ensure that you can close the estate in a timely manner, assuming that all of the creditors have gotten this notice. So if the decedent was not receiving Medi-Cal or is not the surviving spouse of someone who was, then you don't have to give this notice. Same with the California Victim Compensation Board. So here you would be required to give notice if the decedent has an heir or a beneficiary who is or was in prison or a different facility under the jurisdiction of the Department of Corrections and Rehabilitation. So this is something where if information comes to the attention of the personal representative, where they become aware that they have a beneficiary or an heir who falls within this class, then they need to give notice to the California Victims Compensation Board. Again, there's no specific form, but I've listed the type of information that you should include. So a copy of the decedent's death certificate, the name of the beneficiary or heir who's triggered the notice requirement, the date of birth and location of that person, their CDRC number or booking number, and the probate case number, so the Victims Comp Board can track the case. And then notice should be sent not just to the board itself, but to the director of the Victims Compensation Board, because it is not until the director receives this notice, your 4-month time for filing a claim won't begin to run. So it's important to make sure that you've directed it to the attention of the director. And then finally, you have to file a notice with the Franchise Tax Board to notify them that the decedent's passed away and to check whether there are any outstanding tax obligations. And you'll need a letter from the Franchise Tax Board indicating no tax is due before you're going to close the estate. Okay, so stepping back to our third-party creditors, so not state agencies. So as I said, you want to identify them as quickly as possible in order to get, again, that 4-month period started during which they can file claims. And I've given some ways to think about, how to identify creditors. So, with credit card companies, a mortgage or something of that nature, you're typically going to discover it in the decedent's mail. You could also obtain a credit report for the decedent and then review the information you find there. You might look at the decedent's tax returns to see if there's any interest payments reported as deductions. If the decedent was, in a healthcare facility, or you are aware that they had home care prior to death, you want to make sure that there aren't any outstanding invoices. If there are any people that come forward, you don't have to, and the personal representative doesn't have to take and shouldn't take at face value that everybody who says they have a claim against the estate has a valid claim. Rather, for maybe smaller debts, like small credit card payments, maybe a final utility bill, where it's clear that the decedent incurred the liability and that the estate has sufficient assets to pay the debt and still have plenty of funds remaining, the personal representative can pay those smaller obligations without requiring a formal creditor's claim be filed. But generally speaking, the personal representative will want to file a notice to, provide a notice to known creditors, and then wait for a creditor's claim to be filed, and then to review the creditor's claim and determine whether or not they believe it's a valid claim. And just a tip, actually, stepping back on the decedent's credit cards, the personal representative can, of course, simply pay any outstanding credit cards, but it's worth often making a phone call to the credit card company to see if you might be able to negotiate the actual final amount due. It's also important to make sure that no interest was charged after the decedent's date of death if you are going to pay based on a final statement, because under law, interest cannot continue to accrue on those types of liabilities after the decedent passes away. To the extent that a creditor receives notice and then files a creditor's claim within the required period, which is generally going to be 4 months from the date that letters are issued. But if the personal representative doesn't, become aware of a creditor immediately, then they have up to 60 days from the date that they receive notification. So it's the later of 60 days from the date of notification or 4 months after the date letters were issued that a claim is required to be filed with the court. If a creditor, in fact, files a claim within that period, the personal representative will review the claim and decide whether to accept it, reject it, accept it in part, reject it in part on the other side of that. And then depending on whether they accept or reject it, it will sort of lay out the next steps. So for a claim that's accepted, if the personal representative has full IAEA, they have the full authority to act under the Independent Administration of Estates Act. Then after accepting the claim, they can immediately pay the amount due without getting court approval or given any type of notice. If, on the other hand, the personal representative does not have authority or has limited authority under the Independent Administration of Estates Act, then they will need to file an allowance or rejection of creditor's claim with the court to seek the court's approval to pay the claim. Just as a general rule, if you've given notice to all known creditors timely, all creditors, they have that limited period of 60 days or 4 months to file. But if there's a creditor that's not known to the personal representative and they're not otherwise secured, so they don't have a security interest, all creditors must file a claim against the estate within 1 year of the decedent's date of death. So if you can't be certain that you've identified all creditors, or if the personal representative has some concern that there are creditors outstanding, 1 year from the decedent's date of death, if a claim has not been filed, you know that you have your known universe. If, on the other hand, the personal representative is confident that they've identified all creditors, then, once that shorter 4-month or 60-day period has run, you can kind of move forward with the next steps in your administration. If I mentioned, sort of the steps, if the personal representative accepts the creditor's claim, if, on the other hand, they reject the claim, then the creditor will have 3 months from the date of the rejection to file a formal lawsuit against the estate to pursue their claim. And in certain instances, creditors will actually, through their own election, initiate a litigation within 30 days after filing a creditor's claim if the personal representative hasn't acted. So just to be aware, you don't have to, or the personal representative doesn't have to overtly reject the claim in order for the creditor to be able to move forward with the lawsuit. Okay, so I think that's a good coverage of creditors' claims. Let's talk about selling estate property. So there are kind of two circumstances where you might sell assets of the estate. One is if the will directs it, and then the other is if the estate needs the liquidity or otherwise owns assets that it doesn't really make sense to distribute pro rata to the beneficiaries. So an example, a very common example is, an estate that owns real property where you have multiple beneficiaries who don't want to be co-owners. And so the personal representative will sell the home prior to distribution so that everyone's getting their share of the proceeds rather than a tenants in common interest in property. So if you're going to sell estate assets, the procedure that you have to follow depends upon whether the personal representative is acting with full authority under the Independent Administrations of Estates Act or not. If they're acting with full authority, then the property can be sold, through a private sale after giving notice to all of the beneficiaries through a notice of proposed action. That must be provided 15 days prior to the sale and has to include information about the price at which the property will be sold, the broker's fees that will be paid, and a representation that the sales price is at least 90% of the appraised value. And then, assuming that no objections are received, they can move forward with the private sale. If, on the other hand, court approval is required, then first of all, it's really helpful, frankly, if you are in a position where you're selling property, particularly real property, subject to court approval, to work with real estate brokers that are familiar with the court process, because there are particular rules that have to be filed, different forms that need to be used when an estate's involved. So that's just something to bear in mind when you're deciding which agents to work with. But if a sale is subject to court approval, then you would solicit offers. The personal representative could accept an offer, but the accepted offer would be contingent upon obtaining court approval. And then the personal representative would need to file a petition with the court to ask the court to approve the sale, appear at a hearing where the court will indicate whether they think the sale is appropriate, and then if they're inclined to move forward with the sale, give third parties an opportunity to essentially outbid your prospective buyer. So in the court, when we actually appear or by Zoom, there will be what's called an overbid process, where the court will set the minimum bid to outbid the offer, and if anybody outbids, then the highest bidder will win the day. If, on the other hand, there are no overbids, then your buyer, will be able to proceed with purchasing the property once the court issues an order approving the sale. So those things are important to keep in mind just to set expectations on timing and how quickly a closing can occur. So, a sale that's subject to court approval, you have to file the petition to approve the sale, which sometimes is possible, but not always to do on an ex parte basis. Assuming it's not, you have to assume you have, 8 to 10 weeks out for a hearing on the petition to approve the sale. You then have the hearing itself, whereafter you have to file an order with the court and wait for the order to be received, which can take another 30 days before you're actually able to move forward with closing. So something to keep in mind just as you're talking to prospective buyers along the way. Let's see. So, right. So for one of the things that you have to do in connection with the sale of property is to make sure that you have an updated appraisal on file for the court. So before I had mentioned that even if you filed a final inventory and appraisal for the estate, if you sell real property and your inventory and appraisal on file is more than a year old, you have to obtain an updated inventory and appraisal in connection with sale, because that inventory will then set the threshold for the sales price. Generally speaking, you need to sell real estate that's owned by an estate at least 90% of its appraised value. So if you have property that you intend to sell and you know that your inventory and appraisal is getting stale, you'll need to reach out to your probate referee to get a more updated value for purposes of the sale. For personal property, this again depends on the authority that the personal representative has. Generally speaking, you don't have the same restrictions in terms of valuation, but you do, meaning that it doesn't have to sell at a fixed percentage of the appraised value, but you are required to give notice to the beneficiaries if the value, if the property being sold is worth more than $5,000. Okay, so that's general overview of, I see we're getting close on time on selling real property and personal property. Let's just talk briefly about making preliminary distributions. So generally speaking, you wouldn't file a petition for preliminary distributions unless you knew that the estate was going to be open for an extended period of time, or maybe one of the beneficiaries had a real need for a part of their inheritance or for liquidity. Or if you want to avoid interest accruing on any specific gifts that are provided for under the will. So if you don't pay, just as a rule of thumb, if you don't pay specific gifts within 1 year after the decedent passes away, and if the will doesn't specifically say that interest is not required to be paid, then starting on the 1 year anniversary of the decedent's date of death, interest accrues at a rate currently of 7% per annum. So it's nice to make any specific gifts prior to that 1 year date. If you are going to file a petition for preliminary distribution, you have to wait until at least 2 months after the issuance of letters, but generally you're going to want to wait until after the creditor's claim period has expired, because one of the things that the court is going to want to know is whether there are sufficient assets to pay the creditors and after paying the preliminary distribution. So if your estate might be absorbed substantially by creditors, you're going to have a harder time obtaining approval of a petition for preliminary distribution. So I've kind of spelled out within my materials the timing and the information that you need to provide in a petition for preliminary distribution, and it varies slightly depending on whether you're acting under, or the personal representative is acting under the Independent Administration of Estates Act. So I just encourage you to go through that comparison kind of side by side to see the information that you'll need to include. For purposes of time, I'm going to jump ahead to closing our estate. So, at this point, you're in a position where you've marshaled all of the decedent's assets, you've identified all creditors, you've paid in the outstanding debts. If any property needed to be sold, you've completed the sale and you have the sales proceeds in the accounts for the estate. You have filed a final inventory and appraisal. You have filed the decedent's final income tax return and estate tax return if needed. And you're finally in a position now where you can close the administration of the estate. So at this point, you have to prepare a petition to ask the court to approve the acts of the personal representative and then to authorize distribution in accordance with the will or under, intestate succession and in a way that you'll spell out specifically in the petition. One of the things that you would generally need to do is prepare an accounting. So for this reason, I said before, it's really important that the personal representative keep good records so that they can provide those records to an accountant or bookkeeper to put into formal schedules that comply with the requirements for an accounting with the court. In the petition itself, in narrative form, the petition will describe information about the decedent, information about when the personal representative was appointed, when letters were issued. There will be a statement about having met the obligations to give notice to the Franchise Tax Board and any of the other government agencies. There'll be a recitation of the assets that were inventoried and appraised and regarding the character of property. Again, character can be important, particularly when you have intestate succession, because it can determine how the assets are ultimately distributed. The personal representative will describe in detail any actions that were taken under the Independent Administration of Estates Act authority. So if, for example, the decedent sold property or negotiated rental income for property or wound down a business or filed an estate tax return or participated in a litigation on behalf of the estate, you want to take the time to describe in detail the actions that the personal representative took and the results achieved in connection with taking those actions. If the beneficiaries or heirs of the estate are willing to waive the accounting that I've referenced, you'll include waivers of accounts that have been signed by each beneficiary or heir. If not, I've spelled out the actual information that you need to include in detailed schedules. So you'd have to show the assets on hand as of the date of death as inventoried, all of the receipts during the course of the administration, any gains or losses, any liabilities that remain outstanding, any disbursements that were made, any preliminary distributions that were made, and then the assets that are actually on hand for distribution. Even if a full accounting is waived, you still need to make sure you have a clear list of the assets on hand so that the court can actually make an order on how to distribute those assets. You'll include a statement regarding the compensation for both the personal representative and the attorney, unless those are being waived, in which case you'll overtly state that they're waiving comp. And the probate code sets out specifically how the statutory fee can be determined and calculated up to, on a value of an estate, up to 25 million. If the estate is worth more than 25 million, then you need to include a detailed explanation as to how you believe the fee should be calculated on amounts above 25 million. And then going back to, sort of some of the actions that are taken under administration of the Estates Act, or any actions that are extraordinary in nature, even if the personal representative isn't acting under the IAEA. You want to separately describe those actions, both the actions of the personal rep and the attorney, in detail if you're going to request extraordinary comp. So you want to make sure you're telling the court the actions that were taken, how much time was spent on each extraordinary act, and then what you're requesting for fees for any of those extraordinary actions. And then finally, as you're requesting the distribution, it's important to include an omnibus clause in your petition for final distribution. I mention this because it's something that's sometimes overlooked and can create a bit of an issue if you've closed an estate and then later discover an asset that was in the name of the decedent and wasn't otherwise covered specifically by the probate. So an omnibus clause basically says that if after the estate is closed, there are any other assets discovered in the decedent's name, that they should be distributed as set forth in the order. So it helps to make sure that you don't have to suddenly go back and reopen a probate and start this whole process all over again. If you're required to file the petition for final distribution within 1 year. When you open a probate, you'll get a hearing date for the petition for final distribution or a status report. So if within 1 year of opening the probate, you are not in a position to file that petition for final distribution, you would instead file a status report to let the court know what's been done, what still needs to be done, and how much longer the personal representative needs in order to complete the administration. And then whether it's with the status report or the petition for final distribution, the court will review and provide a ruling on it. If the court approves a petition for final distribution, the personal representative would then be responsible for actually transferring the assets. And then after doing so, as a last step, would file a request to be discharged from their ongoing liability in connection with the administration of the estate. So I see that we're right at time. I want to look to see if there's any questions that I can answer. So for anybody that still wants to stay on. So, okay, I see. Are emails okay, or should there be registered letters to creditors or credit cards? So for credit card companies that are creditors of the estate, you would want to send them the formal notice, unless the amount owed is small and the personal representative thinks it's a valid claim, then they can just pay the final amounts due, even without requiring a formal claim to be filed. So I have, if you notify the credit companies, will this cause utilities and accounts to be closed? Meaning the credit agencies. What notifying the 3 major credit agencies puts a tag on the decedent social security number so that no additional credit cards can be opened. And then yes, credit cards should end up being closed, but the personal representative would still also need to reach out to each individual credit card company that they're aware of to notify them of the decedent's death, and should also contact any utilities companies to change the accounts into the name of the estate to the extent that, for example, real estate is being held by the estate and you still need to maintain some of these utilities. Would an executor use an external wealth planner to prepare or review the administration plan? If you mean working with a financial advisor, if an estate is large enough, yes, it makes sense to make sure that the estate assets are invested in a way that is for the benefit of the beneficiaries more generally. I'm not sure if I'm answering that question. I'm going to take 2 more, so I'm just going to scroll through. What if the personal representative sends notices to creditors and creditors do not file a claim? Must the personal representative pay known debts? No. So if the personal representative sends a notice to a creditor and the creditor does not file a claim within the required period, then the personal representative should not pay the debt, because at that point the creditor has missed their opportunity to make a claim and therefore can no longer pursue their claim. Is a published notice of sale for real property required even where all beneficiaries are in agreement for the sale? So the answer to that depends on the authority that the personal representative has. If the personal representative is acting under the Independent Administration of Estates Act, the personal representative still has to send a notice of proposed action to the beneficiaries with the terms of the sale, and then file that notice with the court. That notice has to be sent 15 days before the sale can go forward. If, on the other hand, the personal representative does not have authority to sell under the IAEA, even if all the beneficiaries are in agreement with the sale would still be subject to court approval, which means you have the publication requirement and then have to actually file that petition, and you have an overbid process where outside parties would have a chance to outbid the prospective buyer. I'll do, let's see, one more. So is it better for the personal representative to waive compensation in lieu of receiving it as a beneficiary of the estate because of the income tax for compensation, but no tax on inheritance? Yeah, so generally speaking, that's, you know, a question that you have to consider. So the question is, should a personal representative who's also a beneficiary take compensation? It's sort of a personal decision. If the personal representative is one of many beneficiaries, they may decide that they want to take compensation because the compensation, you know, comes not just from their share, but also the other beneficiary's share, and they've, you know, done a good amount of work in the process, and so are entitled to be paid. If, on the other hand, the beneficiary is the sole beneficiary of the estate, it certainly doesn't make sense from a tax perspective to take compensation, because you then pay income tax on what otherwise would be an inheritance. I think that's all we have time for now. So if anybody has a question that I didn't answer, feel free to email me, and I'm happy to answer any follow-up questions by email. Other than that, thank you so much for attending, and I hope you found the presentation useful.